Let's start our new chapter. The name of the chapter is Contract Law. This chapter is the most lengthiest chapter of the book, and that is why it is also important. You can get around about 25 marks, at least 25 marks from this chapter alone. So this chapter has a very significance. Now let's start. The name of the chapter is Contract Laws. Obviously, in this chapter, we are going to talk about the law that revolves around the contract. Now, there are five essential elements of valid contract. In our daily life, we use the word agreement, but to, to be a valid contract, a contract should have five elements. The first one is agreement. In agreement, one party will give some offer and other party will accept that offer. Then we will say that our agreement is formed. Then there should be a consideration in a contract. Consideration is basically an act or promise to do something. So there should be a consideration in a contract as well. We will talk about each and everything in detail. The third element is intentions to create legal relations. There must be an intention that we are going to create a legal valid contract. Like for example, uh, if let's say there are two brothers and one brother, he asked the other brother, can I have your car? And the other brother say, yes, you can have the car, it is all yours. So it is all yours does not indicate that the elder brother have intention to create legal relation. The smaller brother cannot say that, the younger brother cannot say that, you said the car is all yours. It does not mean that the car is actually his. Why? Because there was no intention to create legal relation. So to form a contract, there must be an intention to create a legal relation. Then capacity. The person should be capable in eyes of the law to form a contract. Like for example, the person should not be a minor. The person should not be under the influence of alcohol, or he should not be intoxicated. He should not be forced while doing a contract. Okay. So he must be capable of performing the contract. And the last one is legality. The contract should be legal. You cannot have a contract of drugs and go to the court and say that, I contract with some person, for selling the drugs, and the other person is not paying me. So, I want my payment back. So you cannot do an illegal contract. So there are five essential elements of a contract: agreement in which there is an offer and acceptance, then consideration, then intention to create legal relationship, then capacity and legality. Now let's discuss the elements one by one. Okay. Before that, first let's see different types of contract. There are different forms of the contract. The first one is a simple contract. It may be written, oral, or inferred from the conduct of the parties. A contract can be a written contract, a contract can be an oral contract, or a contract can inferred from conduct of the parties, which means that from the performance of the parties, you can see that there was a contract. We will talk about that as well when we will move on the chapter. Specialty contracts: a contract that must be in writing, signed, witnessed, and delivered. For example, conveyance of land and leases. Some contracts require prop. Some contracts need to be in proper writing. They should be signed. There must be witnesses there. Okay. So these types of the contract are known as specialty contracts. Usually the contracts by deed are specialty contracts. Like for example, if you are transferring land, conveyance means you are transferring land, or you are leasing something. In such type of the contracts, they are known as specialty contracts, and they should be done by deed. By deed means that the contract should be in writing. The transfer of the land contract cannot be an oral one. Like simple contract can be an oral one, but transfer of the land cannot be an oral one. It should be in writing. It should be properly signed. There should be witnesses that was watching the contract, and properly delivered. Delivered means takes effect properly. Okay. So some contracts need to be performed by deed. Those contracts are known as specialty contracts. By deed contracts are those in which the contract should be in writing, signed, witnessed, and properly delivered. Standard form contract: ready-made contracts available on leave or take basis. For example, bank accounting opening form. Some contracts are ready-made available. You just need to fulfill the requirements and the contract will be formed. Like for example, when you go to a bank and if you want to open an account, there will be a standard form. There will be an application, and that you just have to fulfill the details and you will submit those to the bank, and bank will open your account. So that is a standard form contract that is available on leave or take basis. You can, it is ready made. When you will enter the bank, you can see that contract. You will fulfill the information, and when you will submit the information, the bank will open your account. So that information form is like a standard form contract. Void contract means the contract that is held invalid. The contract which have no legal existence, it is known as void contract. Okay. Now let's understand the elements of the contract one by one. The first one is agreement. And in agreement, there are two things: offer and acceptance. Now, what is an offer? A definite and clear statement showing willingness to be bound on a particular terms without further negotiations. An offer is basically a straightforward, clear statement in which you are showing an intention to the other party that I am willing to be bound on these specific terms and I intend no further negotiations. Like, for example, if I put an offer, if let's say this is my friend, and I will say to him, I want to sell my black Honda car, okay, to you for £2,000. Now, this is an offer that I have made. It is a clear statement in which I am showing intention that, I will be bound on these terms without further negotiations. Okay, without further negotiations, there is no room for negotiations. Such a statement is known as offer. Okay, offerer is a party who is making an offer. Offeree is the one to whom an offer is made. Okay, offeree is the one to whom an offer is made. It can be in any form and it is not effective unless communicated to offeree. A very important point, that offer can be in any form. Like it can be written, it can be oral, and it is not effective unless communicated to the offeree. So, if you have put an offer, and it is not yet communicated to offeree, then that offer is not effective. Now, what does this second point means? I will, try to give you an explanation in an easy way. Like, for example, the thing is, when there is an offer, then offer can be accepted by legally. Offer has ability to be accepted legally. If given an offer to someone, that other party can accept my offer. Okay, so a legal contract can be formed. So that is why, if let's say I make an offer to the other party, and if I made an offer and the other party is not aware of that offer, then I will not be bound with any agreement with him. Like, for example, I will give you just a basic example. For example, you go to a shopping mall and you lost your mobile phone. You go to a shopping mall, you lost your mobile phone, and then you put up an offer, or uh, with the help of mic, or you announce, basically you announce to the people in the mall that I've lost my phone, and my phone, and if anyone who will help me find out that phone, I will reward him with, let's say, £100. Okay, so this is what you have make an offer to someone. Now, let's say there was a person who was not aware of this. He just randomly found out your mobile phone, and he communicated to, let's say, the shopping mall owners, or he communicated the shopping mall administration, and told him that, and they told him that this is the phone I got, and that administration, they gave the phone to you. Now, that person who has given the phone, cause he was not aware of the offer, it was not communicated to him, then he cannot claim for the reward. Okay, so he that is why offer, we say that offer is not effective unless it is communicated. So if a person who found out a phone and hand over the phone to you, and he is not aware of the offer of the reward that you made, then he cannot claim the reward from you. Like, for example, he finds out from someone else that this person had put up the reward, so you can claim the reward, but you cannot. Why? Because that offer was not communicated to you. You were not aware of that offer. So that is why it is not effective unless it is communicated. Offer can be made to a single person, to made to a group of person, or even to the whole world. You can make an offer to the whole world. Like, for example, in form of advertisements that reach around whole world. So an offer can be made to an individual person, group of people, and to the whole world. An invitation to treat is not an offer. Invitation to treat means inviting other party to make an offer. Now, important point that you need to be aware of is that you need to differentiate between offer and invitation to treat. Offer has a legal ability to be, to form a contract, while invitation to treat does not have that. Okay. So offer and invitation to treat are two different things. Offer means you are offering something. Invitation to treat means you are not making an offer, but you are inviting other parties to make an offer. Okay, now which things count as an invitation to treat? Following are invitation to treat. Advertisements, the general rule is that advertisements are invitation to treat, they are not offer. Okay, advertisements are invitation to treat, they are not offer. But an ad is not an offer. However, it would be an offer if no further negotiations were intended. A very, very important point. If the wordings of advertisements are such that there is no further room of negotiation, the party who is seeing the advertisement, he just need to perform accordingly, and the that will amount to acceptance. That will amount to the acceptance. So the advert if the wordings of the advertisement is such that there is no further room of negotiation, then that advertisement will be considered as an offer. But general rule is advertisement is not an offer. Like for example, if you put an advertisement on the newspaper and the advertisement is mobile phone for sale, the advertisement is that mobile phone for sale. Now if someone watched that advertisement, and he contact you, and he cannot say you that you made an offer and I have accepted that you have to give me the mobile phone. If there was further negotiation intended, like for example, he could have asked you that which model is a mobile phone, you know is it new, is it used, and all this stuff, the color of phone. So if there is further negotiations room, if there's further room for negotiation in an advertisement, then that advertisement is not considered as an offer. It is considered as invitation to treat, because the other party will give you an offer. So that is not an offer. However, if the advertisement of the if the wordings of the advertisements are such that there is no further rooms of negotiation, you just have to follow the wordings of the ad, and that will amount to the acceptance, then that will be considered as an offer. Okay, now let's understand this with an example. Here, this example, a very famous case, Carlyle versus Corbolic Smoke Ball Company. So there was a pharmaceutical company, and there was the claimant who was Mrs. Carlyle. The first name is of claimant, and the other one is defendant. This is a very famous case. The manufacturer of a medicine smoke ball advertised in a newspaper that anyone who bought and used the ball properly and nevertheless contracted influenza would be paid £100 reward. There was a medicine company who invented a medicine. The name of the medicine was smoke ball, and they mentioned the advertisement in the newspaper that anyone who will use this medicine smoke ball, they will never catch influenza. Influenza is a disease like flu. So the advertisement was that anyone who will purchase the this medicine and who will use this medicine, he will never contract, he will never have this disease that is known as influenza. And if it happens, then he will be entitled to get £100 reward. £100 reward in 1893 was a big deal. Okay, so this was the case. A pharmaceutical company, they put an advertisement in the newspaper in which it was stated that anyone who will purchase this smoke ball, the medicine, and who will use the medicine, and if he will never catch the influenza. But if he did, then we will pay him £100 reward. Now there was a lady, Mrs. Carlyle. She used that medicine, okay, and did catch influenza. After using the medicine, still she catch influenza. So then, she claimed the reward from the medicine company. But the medicine company stated that the defendant claimed that there was no enforceable contract because Mrs. Carlyle had never notified the company that she accepted its offer. The medicine company who were defending themselves, the Mrs. Carlyle claimed for the reward, but they said that Mrs. Carlyle didn't notify us about the acceptance, and we were not aware of that. But the thing is, the court in this case stated, the court rejected the defendant's argument on the basis that the wording of the advert was such that Mrs. Carlyle need only to comply with the terms of the offer, and there was no further negotiations intended. The court said that the wordings of advertisement clearly state that you just have to purchase that, you have to use that, and if you get the influenza, if you get the disease, you are entitled to the reward. So the wording was straightforward. There were no negotiations in that wordings. So Mrs. Carlyle only need to satisfy your condition. She only need to use the medicine, and that's it. So she was entitled to reward. Okay. Thus, the court said weight was placed on the 1,000 bank account deposit that claimed to show sincerity in the matter, in showing that advertisement was not just mere puff. Court said that the company, they also place a £1,000 bank deposit, which clearly indicates that they are serious about the advertisement. So, the showing of the bank deposit amount, it indicates that they were serious about the matter. They were not just faking that. They were not just doing that for the promotion of their, medicine. Well, they were doing that, but it was not that just for the promotion purpose, or they will not give the reward. So that is why the judge said that, Mrs. Khalil, she just need to comply. She just need to follow the wordings of the advertisement, and that was enough to form a contract, to form an agreement, and you should pay Mrs. Khalil the reward of £100. Okay. So a very simple rule: an advertisement is not an offer. A general rule is that, the most of the advertisement, they are not an offer. Okay. They are invitation to treat. However, if the wordings of advertisement are such that there is no room for further negotiations, you just need to comply with the wordings of advertisement, then that advertisement will be considered as an offer, like in Mrs. Carlil case. Okay. The journal advertisement in the newspaper is not an offer. When someone will see the offer, they will, you know when someone will see the advertisement, they will come to you. That is invitation to treat. That person will come to you to make an offer. Okay. When you put an ad on the newspaper, the person who will watch the ad, he will come to you and make an offer. So that is, the advertisement is invitation to treat. You are inviting other party to make an offer. Okay. So there's a whole lot of difference. Okay. So the general rule is that advertisement is not an offer. But if the wordings of advertisements are such that they clearly show that, you just need to comply with the wordings and no further negotiations are intended, then that advertisement will be considered as an offer, and the person who will follow the conditions of the ad has accepted the offer, and a valid contract can be formed. Okay. Second thing is shop windows display. Shop windows display, if you have put something on shop windows display, that is not an offer, that is invitation to treat. We did this case in the first chapter as well. Fisher versus Bell. There was a act, Restriction of Offensive Weapons Act, that stated that certain offensive weapons you cannot offer for sale those weapons. You cannot offer for sale those weapons. The wordings of the advertisements were, you cannot offer for sale those weapons. There was a shopkeeper who put up a flick knife in his shop windows display. Okay. And when someone saw that, they said that, this person is committing the crime. He's offering for sale the offensive weapon. So they took him to the court, and there he said that a window display was not an offer for sale. Like, if I put something in my window display, if I put something in my windows display, does it indicate, that I want to sell that? Like, for example, if someone come to me and he say that, I want this weapon, I can refuse him. So he said that, the windows display is not offer for sale. I am not offering for sale something. It is invitation to treat. I am inviting other party to make an offer. I am not offering for sale. Other party will come to me and they will say to me, that I want this. No, I want this. And I can refuse that as well, right? I have an option. So just putting up something in shop windows display, it is not considered as offer for sale. It is invitation to treat. When someone will saw that flick knife in windows display, he will come inside the shop and he will offer the shopkeeper that I want to buy that. So that is invitation to treat, where other party is making an offer. So, the point that you need to understand is, maybe the intention of the shopkeeper, well, his intention was to sell something, but he has, cause of the wordings of the law, he was safe. The law said you cannot offer for sale something. But this, he said, was invitation to treat, where the person who will watch the shop windows display item, he will come inside the shop and he will make an offer that I want to, purchase this thing. I am not making an offer, the other person is making an offer. So that is why he was saved. Okay. So advertisements, the general rule is, they are invitation to treat, they are not an offer. Okay. And similarly, the shop windows display is also not an offer. Okay. If something is an offer and other party accepts that, then the contract is formed. Okay. So that, but if something is an invitation to treat, then it does not constitutes a contract, it does not form a contract. So that is why you need to differ the offer and invitation to treat. Okay. Similarly, goods on shop shelves. If there are goods on shop shelves, they are also not an offer. They are invitation to treat. When someone will enter the shop, they will saw something. They will see something in the shop shelf. They will take that from there, and then they will go to the counter, and there they will, make an offer that I want to purchase this. Okay. So goods on shop shelves are also considered as invitation to treat. Then there are two things: invitation for tender and invitation to auction. Now, what is invitation for tender? What is tender? Where, when one party issues statements asking interested party to submit terms on which they are willing to carry out work or supply goods. Now, the tender is usually done in the government departments. Like for example, there's a government hospital, and they want some biomedical equipments. So they will issue a statement, in the newspaper basically, or they will issue a statement on their website that we want like this biomedical equipment, and someone who want to carry out work with us or who wants to supply us these goods, then they can submit their terms. They can submit their terms. So like for example, if I am running a government hospital, and the government hospital needs some, let's say, 4 or 5 biomedical equipments, so I will issue a statement on my website in which I will mention that I want these biomedical equipments. If someone can supply us these equipments, or if someone is willing out to to carry out work with us, or to supply these equipments, then they can submit their terms. Their term means they will submit their terms that yes, we have this available, and this will be the price, this is the delivery time, all the terms they will submit to the hospital. Okay. Similarly, obviously there will be different suppliers, that they will those different suppliers, they will submit the term as well. Okay. So the person who is inviting the tender is making invitation to treat, which means, like for example, if I am putting up a statement on website, the government hospital administration, it is not an offer. If it was an offer, then anybody who would have supplied us these things, we are bound to pay him, and we are bound to get the goods from him. But this is invitation for tender, and it is invitation to treat, where I'm asking other parties to submit their terms, and I have the option to refuse that, right? I have option to refuse that. So if I am inviting someone for the tender, it is not an offer. Okay. If it would have been an offer, the other party, they would have just delivered us those biomedical equipment, as per their own conditions, and they could claim the money from us. They would have said that, you needed that equipment. We have provided you with that equipment. Your tender was an offer. We have accepted the offer. We have given you the equipment. Give us our money. But invitation for tender is not an offer. It is invitation to treat. You are inviting other parties to make an offer. Other parties will be submitting the tender. Okay. And they are offer. They are making an offer. You are an offeree. It is up to you whether to accept that or not. Okay. So this is the difference that you need to be aware of. Okay. One more important point here. Let's say, for example, if in the tender the terms were specifically mentioned, like for example, I want this biomedical equipment from this company. Okay. Or of this color, in this quantity, and in this price. If it is specifically mentioned, then that, and they and if in the terms of the tender it is mentioned that we require. Okay. We may require indicates that may or may not. We may, the word may is very important. That, let's say, if in invitation for the tender you use the word that we may require these things, then may will indicate that there is a room for negotiation. Like for example, you may require, you can refuse that offer. But if you clearly state that we require these things, it is compulsory, or we require these things, we must require these things, then the word must states that you are giving a clear statement. The wordings of the tender is such that there is no further negotiations intended. Then in that case, that tender uh, can be an offer. It can be an offer. Okay. So if someone who has all those things according to your terms of the tender, then uh, that person can transfer you the goods, and you are entitled, you are bound to get the goods from that person. Similarly, like the newspaper, if the invitation for the tender is such where there is a further room for negotiation, then that is invitation to treat. Otherwise, it can be an offer. But most of the time in the tender, because you are asking other parties to submit their terms and conditions, which means you are not clearly giving your all terms and conditions. So other party will be submitting, and you are now offering, and it's up to you to accept that or not. Okay. But in some case, that if the wordings of the tender suggests that the other party just need to supply you the goods according to all of your conditions, then that tender can be considered as an offer. But generally, the invitation for the tender is invitation to treat. Then comes invitation to auction. If you are inviting someone to an auction, advertisement of auction is not an offer. It's very important point that if you have put an advertisement regarding an auction, and someone come to the auction, and you withdraw the goods from the auction, then that person cannot say that you put up an ad that was an offer, and I traveled from far away place to get to the auction to get those goods, and now you have withdraw the goods. Now please pay me the travel expenses. He cannot do that. Why? Because advertisement is not an offer. Remember that advertisement of auction is not an offer. Okay. There are two types of auctions. Okay. Auction is without reserve or with reserve. Without reserve is item in auction will be sold regardless of the price. Okay. And with reserve is that you have set a reserve price for the goods. Okay. If let's say the auction is without reserve, you will sell the goods in any condition. Like for example, uh, if you have put up goods in auction and someone bought those goods for $10, $30, $50, $70, you have put those to sell them. So you will sell them at any cost. But if it is with reserve means that you will set a reserve price. That for example, the minimum price that I will sell these goods for is $100. Okay. So if you do not get the $100, then maybe then in that case, maybe you don't sell those goods. So without reserve, you will sell the goods at any cost. Okay. In auction without reserve, you will sell the goods regardless of the price. But in auction with reserve, you will state a minimum reserve price, and if you are not getting that price, you can withdraw the goods from the auction. Okay. Now, what is an implication of auction with reserve or without reserve? Look, if an auction is without reserve, it means that you will sell those goods at any cost. So when someone will attend an auction, when you will put up the goods for auction, you have make an offer. The other party, they will give their bids. So they are accepting your offer, right? They are accepting your offer, and when the hammer will fall, it will be a contract. Okay. So in without reserve, you are making an offer that I will be selling the goods. The other party, they will obviously their bids will be amount to an acceptance. The bids that they will make, they will be amount to an acceptance. Okay. And when the hammer will fall, the contract will be formed. But in auction with reserve, when you will place up an goods for auction, it is not necessary that at all costs you will sell the item, because you want your reserve price to be met, right? So it means that in that case, you are doing invitation to treat. You are making invitation to treat. So when an auctioneer means the one who is performing an auction, asks from the bid from the parties that who have attended the auction, that is invitation to treat. The bids that will be made, they will be an offer. The bids that the parties in an auction will make, they will be an offer. And if those bids are are more than reserve price, or at least at the reserve price, then when you will accept the offer and a hammer will fall, and there will be a contract formed. So there's a difference between without reserve and with reserve auction. In without reserve, you have to sell the items at any cost. So when you will put up those items in auction, this indicates that you made an offer, and the bids made by the people who have attended the auction, they are deemed as an acceptance, and you can accept any of those things. And when the hammer will fall, the contract will be formed. But in with reserve auction, when you put up the goods, because it's not necessary that all costs you will sold those goods, so that is not an offer. That is invitation to treat, where other parties bids are invitation to that when you will put something in an auction, that is invitation to treat, that you are inviting other to make an offer, and those bids will be deemed as an offer. And if the bids meet the reserve price, or it is greater than the reserve price, then the hammer will fall, and there will be a valid contract form. So that is the difference between without reserve and with reserve auction. Then there's a case here regarding an auction as well. We have already talked about that. Now let's see that. The defendant placed an advertisement in the London papers that certain items, including some office furniture, would be placed up for auction over 3 days. The claimant obtained a commission to buy the office furniture and expended time and expense to travel to bid for the office furniture. On the third day, the lots for the office furniture were withdrawn. The claimant sued for the loss of time and expenses. So, again, there was a person who placed an advertisement in the newspaper that he is going to auction some of the things, and in those things, office furniture was also included. So when a claimant, he lived in some other city, when he saw an ad and he also required the office furniture for his office, so he took money, he obtained a commission from the office, and he traveled to the place of the auction to bid for those for office furnitures. But the defendant, he On the third day, he withdraw the office furnitures from the auction, and the claimant sued him for the loss of time and expense. He said that, because of your advertisement, I traveled to a very far place. I wasted my time, I wasted my money. So he sued him for that, time and expense. He said that, you have to pay me that. But the judge said that advertisement is not an offer. We already talked about that. That advertisement for an auction is not an offer. Okay. So the person who has put up an advertisement, you know, he could withdraw the goods from an auction at any time prior to the auction, because it is not an offer. So he could withdraw the goods before auction anytime. Okay. Like for example, if auction is started, then he cannot do that. Okay. If auction is started, then he cannot do that. Okay. But before auction, he can withdraw the goods. Why? Because the advertisement for an auction is not an offer. A mere statement of selling price in response to a request for information is not an offer. If someone requests me about an information for something, then there, if I, my response does not form an offer. Like for example, if someone says that, if someone asks me about the information, like someone asked me information about my mobile phone. Let's say, he asked me about the information of my mobile phone. So now I will say that, yes, my mobile phone is good. This is my mobile phone model. And I may sell it for, I may sell it for this much amount. So this, just giving this statement in response to a request for information, it does not mean that I am making an offer. If you will ask me about information of my mobile phone, let's say, and I am just giving an information, and in that, I mentioned that, maybe I could sell it for, let's say, 1,000 pounds, then this mere statement does not mean that this is an offer. And you will say that, okay, you are selling for 1,000 pounds, I will take that, I have accepted your offer, and now it is a contract, you are bound to give me the mobile. It does not work like that. So if I'm just giving a statement in response for your request for information, you cannot say that this is an offer and I have accepted that and you are bound to follow the contract. Okay. A mere statement of intention to sell is not an offer. Just giving an intention that, I may sell something, that is not an offer. If my friend, inquires me or asks me about, let's say, my car, and if I use this word, okay, maybe, maybe like, after 10 days, I will sell this car, maybe, then this intention of selling the car, it is not an offer. My friend cannot say to me that, you said that, you maybe sell the car in 10 days, so I have accepted your offer, now you have to sell the car to me. No, it does not work like that. Okay. When two parties make identical or similar offers to each other without knowing that offer the other has made an offer, these are known as cross offers. In such case, no binding contract is made, as no one has accepted the offer made by others. Cross offer means that, for example, if you live in some other city and I make an offer to you that I want to purchase your phone for 1,000 pounds, and you also made an offer to me that, I want to sell my phone to you for 1,000 pounds. So we have made identical offers and we don't know about it. So such an offers are known as cross offers. And let's say if I refuse to accept your offer, let's say for some reason I refuse that, then I can do that. Okay. The cross offers cancels the effect, so I can refuse the offer as well. Okay, maybe for some reason. So the cross offer does not form binding contract because nobody had accepted an offer. Okay, maybe my mind changed, so I could refuse the offer. Okay, this is cross offer. So we have talked about the offer. Now, termination of the offer. How can you cancel an offer? How can you cancel an offer? So there are three ways in which you can cancel an offer: revocation, rejection, and lapse. Revocation means canceling an offer at any time before acceptance, even if offerer has agreed to keep offer open. Revocation must be communicated to the to offeree by an offerer or reliable third party. I put up an offer that, let's say I offered my friend that I will sell my mobile phone to you, and you kept an offer open for 7 days. Okay. Now your friend, he didn't accepted your offer yet. He didn't accepted your offer yet. You can cancel that offer anytime before his acceptance. Okay. You can cancel the offer anytime before his acceptance. So if you made an offer to someone and the other party has not accepted the offer, so you can cancel the offer anytime before the acceptance. That is known as revocation. Revoke even if offerer has agreed to keep our offer open. Even if I promise you that I will keep my offer open, and still I can cancel that. In that case, there is an exception. We will talk about that in the exception section. So the revocation means canceling an offer before acceptance. The revocation must be communicated to offeree by an offerer or any reliable third party. Like, it is necessary that offer should be communicated to the other party. Similarly, the cancellation of an offer, revocation, must be communicated by offerer himself, the one who had made an offer, or any reliable third party. Like, for example, I offered you that I will sell my phone to you. I offered you that if you want to purchase the phone, you can purchase my phone for £1,000, and you haven't accepted that. Our common friends, I let my common friend know that let my friend know that I have cancelled the offer. So that is a good way of communication. Okay, if you have got the communication, then the offer is considered cancelled. But if you didn't receive, if the revocation was not communicated to you, then revocation is not effective. Okay, so revocation can be communicated by offerer himself or any reliable third party. Okay, exceptions, there are some rules, there are some exceptions. The first is, if offerees pay offerer if offeree pays offerer to keep offer open, revocation will be amount to breach of that collateral contract. Offeree could claim damages for that breach, but could not accept offer. A very important point here, that let's say I offered to sell my phone to my friend, and my friend said that I have to thought about this decision, but I am paying you $100. Okay, keep these $100 and keep the offer open for 7 days. Okay, in that case, if I cancel the offer, I can cancel the offer. Okay, I can revocate the offer. I can revoke the offer. But the the amount that you paid me to keep the offer open, that is a separate agreement between us. That is known as collateral contract. Collateral contract is a subcontract regarding the same matter. Regarding the same matter, we did a subcontract. So if I cancel the offer, then you cannot say that I paid you, so you had to keep the offer open, and now I will accept your offer and you are bound to give me your phone. No, you cannot do that. I could cancel that, but I have breached the collateral contract. I have breached your promise. You are entitled to sue me for that. You are entitled to claim that $100 from me. You can say that give my $100 back. You are entitled to claim for that damages, but you cannot accept the original offer. The second is, in case of unilateral contract, offerer can't revoke offer once offeree has begun to perform act that amount to acceptance. I talked about that a contract can be made with an acceptance as well, with a performance as well. It cannot be written oral. By performance as well, a contract can be made. So such a contract, it is known as unilateral contract, in which acceptance is made through performance. Okay, so if there was a unilateral contract, then I cannot cancel the offer. Why? Because when I made an offer, if an other party started doing the performance regarding that thing, then he has done the acceptance. He has started doing the acceptance. Then the contract will be formed, and I am not entitled to cancel that. Now let's look at the example here. Now the third example regarding the unilateral contract. A father offered to transfer his house to son if the son paid mortgage. The son began to pay mortgage, but the father died. His personal representative wanted to withdraw the offer. Okay, so there was a case in which father offered his son that I will transfer the house to your name if you will pay the mortgages or installments of the house. Now the son started paying the installment of the house, but unfortunately the father died, and his personal representative, who may be his executor, like his lawyer who deals with his matter, they wanted to withdraw the offer. They wanted to cancel the offer. They wanted to revoke the offer, but they could not. The court said that when once the offer was made, the son start doing the performance by paying the installment. So the performance is started, so the contract is formed. So this offer cannot be revoked. This offer cannot be cancelled. Okay. There was another case here. The defendant agreed to keep an offer open for 2 days. However, in meantime, defendant sold the property to a third party. The offeree was told of the sale by a third party, but then attempted to accept the original offer. So defendant made an offer to someone and promised him that I will keep an offer for 2 days. But in those 2 days, instead he sold that property. The offer was about property. He sold the property to some third party, and the third party communicated to the original person that to whom the offer was made, that that I have got the property from offer. And now the party who to whom an offer was made, he cannot accept the offer, and he cannot say that the contract was done. The contract is you have done an agreement with me. He cannot do that. Why? because the revocation was communicated. And if the revocation was communicated, so the before acceptance, the offerer could have cancelled the contract at any time. Okay. An offer was posted on 1st October. It reached the claimant on 11th October. The claimant immediately cabled his acceptance. In the meantime, the defendant had changed his mind and posted a letter of revocation on 8th October. The revocation was received by the claimant after he had cabled his acceptance. The revocation did not take effect as it was not communicated to the claimant prior to acceptance. The contract was therefore binding. So, a very simple contract in which one party posted an offer to other party, and he posted an offer on 1st October. It reached the claimant on 11th October. The claimant immediately accepted. Like, for example, I made an offer to you on 1st October. You are living in some other country. My offer reached you on 11th October. But on 8th October, my mind changed and I send you a letter of revocation. And that letter of revocation was received after, you received original offer and after you accepted that. So it means that my revocation was not communicated to you prior to your acceptance. So a contract is formed. So a contract is binding. So I am bound to perform the contract. Okay. So this is about revocation. Okay. Revocation means canceling an offer at any time before acceptance. Revocation is not effective unless it is communicated to the third party by an offer or reliable third party. Not communicated to offeree by an offerer or any reliable third party. There are two exceptions: that if someone pays me to keep an offer open, then if I revoke the offer, if I cancel the offer, I am entitled to return him the amount, the collateral contact that I did. I'm entitled to return him that amount, but I am not bound uh, by his contract. Okay. Or he cannot force me that I have accepted the offer and the contract is done. And in case of unilateral contract, if the other party, the offeree, has started doing the acceptance with his performance, then that will amount to an acceptance and that will form a legally binding contract. You could not cancel the offer at that time. The second way of canceling an offer is rejection. Simple. Just reject the offer. If I offer you something, if I offer you to sell my phone, you reject it. You directly say that I don't want your phone. Or by making a counter offer. Counter offer is an offer made in response to an offer. Okay. Like, for example, uh I offered you that I want to sell my phone to you for £1,000. You say that I want your phone for 900 pounds. You had made a counter offer. So once you have made a counter offer, the original offer of £1,000 is cancelled. If, let's say, I refuse to sell my phone for 900 pounds, and you said okay, give me for £1,000. No, now I am not bound for giving you the phone for £1,000 as well. Why? Because by making a counter offer, you have rejected the original offer. Okay. So counter offer uh, can be rejected. The counter offer is a way to reject an original offer. Okay. A mere request for further details doesn't constitute a counter offer. Okay. If you are just asking for the request about something, and against your request I gave you a detail, then it does not mean that it does not mean that this is a counter offer and the original offer could not be accepted. Okay. So, okay, rejection. Like, for example, if you made an offer to me, okay, and if I asked a detail, like, for example, I made you an offer that I want to sell my phone for £1,000 to you. Okay. And you just request for the further details. You ask me that uh, what color is your phone? Okay, what color is your phone? Like, say, for example, what color is your phone? Now, this just requesting the further details does not mean that I have made a counter offer. Just requesting for the details doesn't mean that I have made a counter offer. So the offeree can accept my offer. Okay. You cannot say that he asked me for the details, so he has made a counter offer, and I am not bound to give him the phone or anything for the original offer that I made. Okay. You cannot do that. The last way is lapse. Lapse means the expires. The offer expires. Okay. It lapses. How the offer lapse? Death of offerer. Death of offer. The party who made an offer, he died. Unless offeree accepts in ignorance of death, it is very important point. Like, for example, if a person A made an offer to person B of selling something, and person A died, offerer died, but B is not aware of that, and and in ignorance, he is not aware that the offerer has died, and he accepted the contract. He sent the letter of acceptance. Now, in that case, the personal representatives of the offerer are bound to follow the contract. But if the offeree knew that offerer has died, then in that case the offer will lapse. He cannot accept that. Okay. Death of offeree, the party to whom offer is made, if he dies, then who will accept the offer? The offer will lapse. Failure of a condition. When the offer was made, there were different conditions that were mentioned there. Okay. And if any of the condition was not fulfilled, then the offer will lapse. Okay. Let's say I made an offer, and in that offer there were different conditions. There different conditions mentioned that I will follow the certain conditions, and if I don't follow them, then the offer will be lapsed either by offer or by offer after expiry of fixed terms or reasonable time. Let's say, for example, you made an offer and that was open for 5 days, and 5 days passed, the offer will lapse. Okay. Or uh, reasonable time. Reasonable time means everything has some reasonable time. Like for example, if I make an offer to you for selling a mobile phone, and you respond to me after 12 months, after 12 months you come to me and say, oh, I have accepted your offer. No, you cannot do that. Why? Because reasonable time is past, the offer has lapsed. Now reasonable time depends upon the subject matter of the contract, regarding which thing the contract was going to be made or the offer was going to be made. Okay. So offer can be rejected in three forms. Revocation must be communicated. Rejection, you have to reject an offer or make a counter offer. Or lapse, in according to these conditions. These are the ways in which you can cancel an offer. Acceptance. Now agreement has two things: offer and acceptance. Now what is acceptance? Unqualified, unconditional assent to all terms of offer is known as acceptance. Acceptance means that without any further reservations, you have accepted the conditions, the terms of the offerer. That is known as acceptance. If you had any reservations, then obviously you will counter him. Then then that is not an acceptance. That will be a counter offer. But without any further reservations, if you are agreeing to the term of the offerer, or if you are agreeing to the term of the offer, it means you have accepted the offer. Acceptance can be made orally, can be made written, or by conduct as well, that we just studied the case about the son. Offerer can specify a particular mode of acceptance. However, if he merely requests the mode, offer is not limited to that mode. Okay. The thing is, like for example, if I send you an offer, and in an offer I will mention that uh, you have to give your acceptance in writing. Okay, you have to give your acceptance in writing. Then you can make an acceptance in writing only. Why? Because I have specified you that in this form I need acceptance. But if I just request you, if let's say I just say, if it is possible, made an acceptance to me in written, then in that case, you can make an acceptance orally as well. You are not bound by that mode. Okay. So if I specify a particular mode, if offer specify a particular way of communicating the acceptance, then you have to follow that. If you just request that, then you are not entitled you are not bound to just follow that mode. You can use the other ways as well. As a general rule, acceptance is not effective unless it is communicated. However, there are few exceptions. Similarly, just like offer, acceptance is not effective unless it is communicated. But there are general exceptions as well. Okay. General rule is that you have to communicate the acceptance. But there are few exceptions in which case the communication is not necessary. Okay. Now the acceptance, uh, one exception, we have already discussed about that exception as well. Uh, that was in Mrs. Carlyle and carbolic small ball case, like right, in which uh, Mrs. Carley just need to comply with the terms of the advertisement that was considered as an offer. She did not need to communicate that. She just need to comply with the terms. So, if the performance, if if you have done the performance that amounts to an acceptance, then in that case it is not necessary to communicate the acceptance. Okay. Like in the son's case as well, where son was paying mortgages, he was doing the performance. So he does not uh, expressly need to communicate the acceptance, that I have accepted. He did not need to communicate to the father that I have accepted your acceptance, I have accepted your offer, and I am paying the installment. Just paying the installment without expressly communicating the acceptance, it is indicating that paying the installments is indicating that you are doing an acceptance, you are accepting the offer, right? So these are the few exceptions. Okay. Now there's a case here. then you need to understand. The case is in your book, Entor versus Mile Far Eastern case. And that case is about that if let's say someone, if let's say the offers and acceptance, they are made in form of fax, telex, or telephone messages, then what rules apply? If fax, telex, or telephone messages is received, or even you can say email is received during normal business hours, that is when it is communicated, even if it is read later. Now the thing is, acceptance is not effective unless it is communicated. We just talk about that. There were few exceptions. The one exception was the unilateral contract, when where the performance is started by, where the performance amounts to an acceptance. Okay, but the other is that, let's say, if acceptance is received in form of fax, telex, telephone messages, and let's say the email, and it is received during business hours, then we will assume that the acceptance is communicated even if you have read that later. Like for example, if I made an offer to someone and that person send me the acceptance in my email, I haven't read the email yet, but he had sent an acceptance in form of email. Like for example, after before reading his mail, I revoke an offer. I text him that I have canceled the offer. I cannot do that. Why? Because when once the acceptance is received during the business hours, let's say we are talking about the business context, 9 to 5, if the acceptance is received in within 9 to 5, then it means the communication is done. Even if I read that mail, even if I read that message, fax, telex later, okay, the acceptance will be done. Okay, that is an exception, because communication means you are aware of that. But in this case, if the acceptance is made via fax, telex, telephone messages, email, WhatsApp, anything, once the other party has sent the acceptance message, it is communicated. If it is in business contact, then in the business hours we will assume that acceptance is done. I cannot cancel that. But if the fax, telex, or telephone message is received outside the business hours, it is considered to be communicated when business next opens. Like for example, on Friday at night 9 a.m., I got an acceptance message, and now that acceptance message was because outside the business hours. So the communication will be assumed to have done when the next business opens, that is Monday 9 a.m., Monday morning 9 a.m. Okay, so if the acceptance is communicated outside the business hours, then we will assume the acceptance is made once the business next open. So without pre-communication, I can cancel that. Okay, but if it is made within business hours and even I did not read that, still the acceptance is done, I cannot revoke an offer. Okay, offerer can't stipulate that he will consider silence as an acceptance. The offerer, the party who made an offer, he cannot say that, I am going to make an offer, and if I do not hear from you, if I do not hear any reply from you, I will assume that you have accepted the contract. You cannot do that. Okay, we will just talk about the case of this point, but before, there's an exception to this rule about the communication. That is a postal rule. Okay, postal rule states that acceptance is completed when letter is posted. It only applies if letter is properly stamped, addressed, and posted, and post is a reasonable method of communication. The general rule states that acceptance is effective when it is communicated, right? But the postal rule is exception. Postal rule states that when one party has posted an acceptance letter, that is when the communication is done, regardless of the when the other party will receive that acceptance. So once the party have posted the acceptance letter, the postal rule says that this is where the acceptance is made. But it will only apply if you have properly stamped, addressed it, and posted the letter, and the post is reasonable way of communication. Like if there's any other reasonable way of the communication, then you have to follow that. Like for example, in today's world, let's say if I made an offer to someone, he can just make an acceptance with the WhatsApp as well, right? He can text me, he can mail me. Now in that case, if he use postal rule, I will say no, the postal rule is not relevant, it's not valid. So the post should be reasonable method of communication. However, however, postal rule doesn't apply if offerer states that he must actually receive acceptance. But if the offerer in his offer will mention that, when I will receive an acceptance, that is when I will consider acceptance, in that case, the postal rule will not apply. Okay. Now let's read a case about this point, that if offerer can't stipulate that he will consider silence as acceptance. Okay. Now let's understand this with the case Feldhaus versus Bindley. The claimant was interested in buying a house and had discussed with his nephew to purchase a horse belonging to him. So there was an uncle who wanted to purchase the horse from his nephew. Uncle wanted to purchase a horse from his nephew. The claimant wrote his nephew and stated that if the, he that this letter in his letter that he assumed that the horse was his for 30 pounds and 15 cents if he did not receive a response from his nephew. So uncle made an offer to his nephew. Basically, he sent a letter in which he said that he is assuming he is assuming that if the acceptance is not made by the nephew, I am assuming that the horse is mine for 30 pounds 15 cents. Okay. Now what happened was the nephew did not reply. When the nephew received the letter, he didn't made any acceptance yet. He did not reply. Okay. And instructed the defendant, an auctioneer he had engaged to conduct a sale of his farming stock, to withhold the horse from the auction. So what happened was that the nephew had put up the horse in auction. Okay. The nephew put up that horse in an auction. The nephew, when he received the letter of uncle, he contacted the auctioneer once who was performing an auction and asked him to withdraw this horse. Okay. And asked him to withdraw his horse because his uncle wants that horse. But the auctioneer, by mistake, he put up the horse in an auction, and the horse was sold in auction. So the uncle Feldhaus, he sued auctioneer. Uncle sued the auctioneer, put up the claim for damages. A very interesting case. Okay. Uncle wanted a horse from his nephew. Uncle sent him a letter in which he stated that, I will assume this horse as mine for this much amount if you didn't reply to me. When the nephew received the letter and he didn't reply to the uncle yet, he asked the auctioneer who was responsible for selling his livestock, in which the horse was there. The nephew requested the auctioneer to withdraw or withheld the horse from the auction because he wanted to send that horse to his uncle. But the nephew didn't yet communicated that. Okay. So the auctioneer, by mistake, he sold the horse in an auction, and uncle sued the auctioneer for damages. Now, what did the court said? An acceptance of offer will not give rise to a binding agreement unless it is expressly communicated to the individual who makes an offer. The court said that the nephew had not made an acceptance yet. If he had not made an acceptance yet, you cannot claim that the horse was yours because the acceptance was not made. Even the court said that nephew has an intention that he will be giving the horse to you. Yes, he had an intention, but he didn't communicated the acceptance. He didn't communicated the acceptance. If he didn't communicated the acceptance, the contract is not formed. And if contract is not formed, uncle cannot claim for the damages because the contract was not formed. So from this case, you have to understand that an offerer cannot say that I will assume your silent as an acceptance, and acceptance should be communicated. Okay. Now, next thing is consideration. We have talked about agreement. The first element of the contract was agreement, in which there was an offer and acceptance. Offer was basically a definite and clear statement in which you are showing a willingness to be bound on a specified terms. Offer was not effective unless it is communicated. Uh, Advertisements are not an offer unless the wordings of advertisements are such that you just need to comply with them by comply with the terms of the wordings to make a legal agreement. Okay. Or make a contract. Then the shop windows display and goods on shop shelves, they are not considered as an offer. They are invitation to treat. Invitation to auction is also an invitation to treat. Invitation to tender is also a invitation to treat. Okay. Offer could be cancelled. The offer, you can cancel an offer with the help of revocation, rejection, or by lapse. Then we talked about the acceptance. Acceptance is basically without any reservations. You are complying, you are agreeing to be bound, you are agreeing to follow the terms of the offer. That was acceptance. Acceptance must be communicated. It is not effective unless it is communicated. Exception is that if a postal rule, if you post the letter, that is when you will consider that this is acceptance is made. But if the offer states that when actually he will receive an acceptance, that is when he will consider the acceptance, then acceptance will be done once the acceptance is communicated. Okay. Now the next thing is consideration. Now what is consideration? It is an act or promise of it by one party of the contract against the price of the promise made to him by other party. I did a contract. I made a contract. Let's say I made a contract with someone that I will sell. I made an agreement that I will sell my mobile phone to you for £1,000. Okay. Now, consideration from my side is promise. Promise that I will sell the phone to this person. And consideration from the other party is that he will pay me the price. Okay. So the promise of one party and price of other party is a consideration. Okay. So consideration is basically an act or promise by one party against the price given by the other party. That is consideration. So if for a contract to be legal, to be valid, there must be some form of the consideration in the contract. Okay. For a contract to be valid, there must be some form of consideration. Every simple contract must be supported by consideration from each party. However, contracts made by deed don't require consideration unless the terms of agreement require. The contract that are made by the deed, which are properly signed, witnesses in writing, in that contract you don't need a consideration. But the same other contracts you need a consideration. Okay. There are two types of consideration: executory consideration and executed consideration. Now what is executory consideration? When there is an exchange of promise to do something in future, the act or the promise that you have made to each other, you will do that in future. That is known as executory consideration. Like for example, you know you and let's say you and I did a contract. Okay. Party A and party B did a contract, and the contract was regarding the sales of goods on credit. Okay. I want the goods. I contracted with you that I want the goods from you. Okay. And you will sell. Okay. You said that I will transfer you the goods. Now the thing is, the transfer of the goods, the promise of transferring of the goods is in future, because you are making the sales, or you are doing the contract, you are making the sales basically on credit. Okay. Like for example, uh, you are a supplier. I am company representative. I am a customer. I contracted with you that you will supply me the goods after 14 days, and once the good is supplied, I will make you the payment. Okay. Now you will supply goods after 14 days, so your consideration, your promise to supply the good is in future. I will make you the payment when the goods are received. So the contract is done now, but the consideration, the promise of performing an act regarding the contract is in the future, right? You have to do something in future. So that is executory consideration, when there is an exchange of promise to do something in future. So this is an example of executory consideration. Executed consideration is that the act or the promise is carried out at the time when the contract is made. Like for example, I go to your shop, I go to a supplier shop, I paid him the money and he gave me the goods. That is executed consideration. That when the contract is done, when the agreement is made, at the same time you have paid the amount, or the other party have performed the promise. That is executed consideration. Okay. So executed consideration is then there's exchange of promise to do something in future. Executed consideration is then when you are doing that act, or performing the promise at the same time when the contract is made. When I purchase something from someone, that there's a contract form, right? A contract is formed. So I am paying the amount, that is consideration from my side. He's giving me the goods, that act is consideration from his side. Sufficient consideration. Consideration must be sufficient but need not to be adequate. A very, very important point. Like for example, in eyes of law, consideration must be sufficient but not need to be equal in the value. Like for example, if I go to a shop and if I purchase a phone that's market value is £1,000 for £200, okay, now the consideration, the £200 that I made for the thing that is of £1,000, now the consideration is not equal, right? But the law says consideration just need to be sufficient. That's it. If I pay £200, that is sufficient consideration. That will amount to a contract forming. That will amount to a contract forming. So it's not necessary that consideration from the both parties should be equal. If the other party gave me the phone of £1,000 just for £200, he did a contract with me, then the £200 consideration is from my side, and from his side he gave me the phone. Now later on, he cannot say that, give my phone back to me, because you did not pay equal consideration. Because in eyes of the law, to form a contract, consideration must be sufficient, okay, but not need to be equal. Sufficient means that there must be some monetary value to it. In the consideration must have some monetary value, and it must be capable in law of amounting to the consideration. The law considers that thing as a consideration, okay. Like for example, there's a case, a very important case. A promise to lease a house for a widow to a widow for rent of £1 a year was binding. So it's a very interesting case here, Thomas versus Thomas. So uh, there was a widow. There was a widow who got a house on lease from, I think his husband. Okay, husband gave his house on lease to wife. Okay, now the thing was, against that, the wife paid £1 a year. Okay, £1 a year. Look, now this is not equal, right? Husband is giving the whole house on lease house, and against the house, the rent is only £1 a year. Per year, only £1. So the consideration is not matching on the both sides, right? But because the consideration had some monetary value, then this lease contract is a valid contract. It is binding. Binding means it is compulsory to perform that. Okay. Now the thing was that the husband, he leased the house to the wife, and the wife, she paid £1 a year contract, which £1 a year rent for the lease, for for the house. And according to the eyes of the law, that is considered as sufficient consideration, and the contract was a binding. So nobody in the future can, can ask the wife to get away, to get out of the house, because the contract is not formed. Why? Because the consideration was not equal. So that is why when the contract was made between husband and wife, because the sons were also entitled for the house as well. So to form a valid binding contract to save his wife, the husband, ask his wife to, you just pay £1 a year. So at there, so there should be some consideration. And if there's a consideration in the contract, then the contract is considered binding only. Okay. So that is why, to save the wife, husband did a contract in which a very minimal amount of the rent was set, and wife, had to pay that rent, and that rent amounted to the consideration. And if there is a consideration in the contract, then the contract is binding, and nobody can, ask, or nobody can force the wife to get away from the house, and by saying that, this contract is not valid because the consideration was not equal. Okay. So consideration must be sufficient. Okay. Consideration must be sufficient. Okay. Now, in the book, there's a point mentioned: a son's promise to stop complaining did not amount to consideration, as it had no monetary value. So, if you are promising that, I will not complain, if you are promising your father that, I will not complain anymore, and against that, you ask your father to give you something, then that's not a consideration from your side. Just promise of not complaining is not a consideration, because it has no monetary value. So, consideration should have a monetary value, and it must be capable in the law of amounting to consideration. Very important point. Rules on consideration. Past consideration is insufficient and therefore invalid. However, past consideration can be considered valid in business situations. The past consideration is considered insufficient. Now, what does the past consideration means? Now let's understand this with a case. Okay. A mother and her three grow-up children lived together in a house. One of the sons and his wife did some decoration of the house. Okay. So there were three children, and one of the sons and his wife, they decorate the house. Let's say they decorate the house, and let's say decoration expenses was $100, for example. And later, the other two children promised to pay towards the decorating cost and signed a document to this effect. Now, try to understand this case. There were three children and one mother living in a house. One of the children and his wife, they decorate the house for $100, and then they signed a document in which they said that the other two will pay. Other two children promise that they will pay towards the decorating cost. So this is the case. Now the thing was, the other two in the future who promised that we will pay our share of decorating cost, they refused to pay the decoration cost. And then the son and his wife, they sued them. They sued them that they have to pay they put a claim on them that they have to pay the decoration cost. What did the judge said? Very important. It was held that promise was unenforceable as all the work had been done before the promise was made, and therefore was past consideration. The act performed by his son, by one of the son and his wife, that was in past, and after that they made a promise. you know the consideration was in past and then they made a promise. So the past consideration is insufficient and invalid. They should have first made a promise. They should have first made a promise. They should have first signed an agreement, and then they should have paid the decoration cost. But so the judge said that the consideration from the son and his wife, the act that they perform, that was done in the past, and afterwards the contract was made, afterwards the agreement was made. So that is unenforceable. Why? Because the consideration was in past. Past consideration is insufficient and therefore invalid, and it does not form any binding contract. So the other two who promised that they will pay and they refused that, they were not held accountable. So that is why the consideration should not be made in past. Past consideration is insufficient and invalid. Those who incur the decoration expenses, they should first take the promise from the two sons as well, and then perform the act. Then the consideration should not be considered in past, because their act was done after an agreement. So that is not a past consideration. Okay, consideration can be an act or promise by one party against the price paid by other party. Okay, so it can be anything. But there's another point here, another point. However, past consideration can be considered valid in business situation. So in business situation, past considered can be held valid, but normally, generally, it is insufficient and therefore invalid. So in business situation, past consideration can be held invalid. Now let's understand this case. A and B owned a patent, and C was the manager who had worked on it for 2 years. A and B then promised C a one-third share in invention for his help in developing it. The patents were transferred to C, but A and B then claimed for the return. Okay. Now the thing was, I will just try to make this case clear. C, he managed the patent. You can say like he managed the software of A and B. Okay. He developed a software. He managed the software of A and B. Okay. And against that, A and B promised him a reward. Okay, one third of share of the profit. C, let's say, developed a software for A and B, and once the software was developed, A and B promised C that we will give you the one-third share of the profit. Okay, one-third share of the profit that we will earn by using this software. Okay. Now the thing was, they then refused. A and B refused. They said that the software was already developed and invented, and after that we make a promise. And that promise, because the act by C is already done, so that is a past consideration and it is invalid. But the judge said that in business situation, the past consideration can be held valid. C could rely on their agreement even though his consideration was in past, but it is been done in business situation at request of A and B. And it is understood by both sides that C would be paid, and the subsequent promises to pay merely fix the amount. Therefore, was an implied promise to pay as the development of the patent had been requested by A and B. So, this is exactly what judge said, that, yes, you requested him to develop and invent the software, and once he had done that, then you promise him that when we'll use the software, we will reward you. Yes, the C's consideration was in past. The act of developing the software he has already done, but he could rely on that. Why? Because if it is done in the business situation, then the past consideration can be held sufficient, and it will be valid. So A and B are entitled to pay the reward to C. Okay. So past consideration is sufficient, is not sufficient and invalid, but in the business situation, past consideration can be considered sufficient and valid. Okay. Performance of existing statutory or contractual duty is not sufficient consideration. if you are performing your existing statutory means what the law says to you, and contractual duty means what the contract says to you. If you are just doing that duty, then it will not considered as sufficient consideration. And if it is not a sufficient consideration, it is not a binding. Okay, it will not be a binding. Now, for example, I will just give you an example of statutory one. Like, for example, there was a witness who was promised that he will be paid if he would attend the court and give evidence. So an incident happened, and there was a witness of that incident. Now that witness was that witness, the representatives of one of the party, they asked that witness, that we will pay you the reward if you go to the court, and if you give the evidence about something. Okay, so that was the case. An incident happened. There was one person who was watching all of that incident, and that person was promised that he will be paid some amount, he will pay the reward if he go to the court and give evidence about that incident. Now, once he went to the court, he gave the evidence, the parties refused to pay him, and he sued them for the amount. He go to the court and said that they promised me the payment and did not pay me. What did the judge said that you were watching the incident, and it is your duty by law to give an evidence. It is your statutory duty. If someone is watching, if a public is watching something is going bad, then, and if he is a witness, he should give the evidence. That is his duty by law. So you cannot say that 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 my act of going to the court and giving an evidence, it is a consideration, and there's a contract form, and the contract is formed, so I'm entitled to the payment. No, you are not. Okay. Similarly, performance of existing contractual duty is also not a sufficient consideration. Let's read a case here. A captain promised to share the wages of the deserting seamen with the rest of the crew who had contracted to sail the ships home. Okay. Deserting seamen means ones who were leaving the ship. So in this case, there was staff, and out of the staff, 3-4 staffs, like I think 5 staffs, 5 staff members, they refused to, they refused to go with the ship. They refused to sail the ship, and the captain of the ship, he promised, that okay, okay, it was like yes, yes, okay. So there were ship members who had obviously the contractual duty to sail the ship home, but they refused to sail the ship home. They said that we are leaving the ship. We are not going to we are not going to sail the ship to the our destination. So the captain of the ship, he promised them that if you will help me to sail the ship to the destination, I will pay you extra wages. Okay, I will pay you extra wages. So the case was like this, that there were some staff members, due to some reason, they refused to sail the ship to his destination, sail the ship to the destination. They said that we are leaving the ship, we are not going to sail the ship home. They were staff members, they were contractually bound to do that, but they refused that. So the captain of the ship at that time promised them that I will pay you the extra reward if you will help me sailing the ship home. Now those staff members, when they heard about the extra reward, they said, okay, let's sail the ship to the destination. So they did that, and when they got to the destination, captain refused to pay them any amount, and he could do that. The judge said, when he refused that, then the staff members sued him, claimed the amount of compensation on the captain, and go to the court. The court said that the sailing the ship to the home, it is your contractual duty, and performance of existing contractual duty is not a sufficient consideration. It was your contractual duty to perform this task. So the promise that the captain made, okay, uh, he could refuse that. He could get back from the promise, he could withdraw the promise. Why? Because the contractual duty that you are performing, it is not considered as sufficient consideration. And if it is not a sufficient consideration, there is a no valid binding, there's no valid agreement regarding that promise. And if there's no valid agreement, then there's no contract, and captain is not entitled to pay you anything. Okay, the performance of existing statutory and contractual duty is not a sufficient consideration. But there are 3 exceptions to this rule. There are 3 exceptions to this rule. Number 1, if existing contractual or statutory duty is exceeded, then there is a sufficient consideration. If let's say you were contracted to perform 8 hours, but you are doing 12 hours, then extra 4 hours, the act of doing that extra 4 hours can be amount to a sufficient consideration. Now let's read this with a case. A high number of desertion from a merchant ship rendered the vessel unseaworthy, since it was now undermanned. A very difficult technical language is used. Desertion means people leaving the ship. Rendered the vessel, rendered means caused the vessel unseaworthy, unfit for sea voyage, because it was now undermanned. So what happened was, there was a ship, and high number of the staff of the ship, they, they refused the ship to sail. They refused to sail the ship to the destination, and they left the ship. Now, what happened was, only few members were left. Ship was now undermanned. The labor got reduced, and only few members were left. The captain of the ship, he promised extra pay to the crew who remained loyal and sailed the ship home. The people who were left on the ship, high number of the people, high number of the staff, they left the ship, and they said, we are not going to sail the ship home. They left it. Those ones who were in the ship, captain promised them that, I will pay you extra amount if you will remain loyal with me and if you will help me sailing the ship to our destination. Now, the those ones who were in the ship, they helped the captain to sail the ship home, and the captain refused when the ship went to the destination. Captain refused to pay the extra money to them. Okay, but in this case, the judge said, because a high number of the staff members were have left the ship, like for example, if there are 100 staff people, and let's say high number means 50 have left, the other 50 were doing the job of 100. Other 50 were doing the job of 100. So they were exceeding their existing duty. They were exceeding their existing duty, and exceeding the existing duty is considered as sufficient consideration. So and if it is a sufficient consideration, then there's a valid promise, and you should pay them extra money. It is recoverable, right? Because they are exceeding their contractual duty. So if you are exceeding your existing contractual duty, and then that will be amount to a consideration, sufficient consideration, and in that case the contract will be formed, and the captain is bound to pay you the extra reward. While in the other case, because you were just doing the thing that you need to do, existing duty, you were not exceeding that, then in that case that is not a sufficient consideration. Okay, performance of existing contractual duty may be sufficient if it confers some benefit of practical nature to other party. A very important point. You are doing your existing duty, but because of your existing duty, the other party is getting some extra benefit as well. You are doing your existing duty, but because of your duty, the other party is getting some extra benefit as well. Then your existing duty will be considered as sufficient consideration, and it can form a valid contract. Okay, now let's understand this with a case. 1990 case. W agreed to do some carpentry in the block of flats for R at a fixed price of 20,000 by an agreed date. The contract contained a time penalty clause, and R agreed to pay an extra 10,000 to ensure that work was completed on time. Okay, so W, he was a carpenter, R was a contractor. W was a carpenter, R was a contractor. So W did a contract with R that he will do some carpentry work in flats, and the price agreed was 20,000 pound. Okay, and in the contract there was a clause mentioned, a time penalty clause, that in which R stated that I will pay you 10,000 pounds extra if you will do the work on time. Very interesting case. W had a contract with R, and the contract was of 20,000 pounds. And in the contract, there was another clause mentioned in which R, who was contractor, promised that I will pay you 10,000 pounds extra if you will do the work on time. And R would have suffered a penalty in his own contract with the owner of the flats. R, who was a contractor, he already did a contract with the owner of the flats, and the in the contract which he did with the owner of the flats, it was mentioned that if the work was on late, then R could suffer the penalty. So this is how the case went. Now what happened was that when the carpenter performed the work on the time, R refused to pay him 10,000 pounds extra by giving this logic that the carpenter is doing his existing contractual duty. It is his duty to do the work on time. And if it is his existing duty, then there is no sufficient consideration. And if there is no sufficient consideration, there is a no valid promise regarding 10,000 pounds, extra payment. So I am not entitled to pay him. This is the logic that R presents in the front of the judge. But the judge said that because of the existing contractual duty of the carpenter, you got saved from the penalty of the owner. So the existing duty gave some benefit to you as well. And if the existing duty is giving some kind of the benefit to other party of the practical nature, then this this will be considered as sufficient consideration. Then the R is entitled to pay Williams 10,000 pounds extra. No, it's very interesting. If it is not considered as sufficient consideration, then it is not a contract. No, there's no agreement. If there's no agreement, R is not entitled to pay him 10,000 pounds extra. Okay. So that is why you need to understand the logic behind the consideration. Okay. So if you are doing existing contractual duty, and because of that the third party is getting benefit, then that performance of existing duty will be considered as sufficient consideration. Okay. So in that case, the judge ordered R to pay 10,000 pound extra to carpenter. Performance of existing contractual obligation is sufficient consideration to support a promise from third party. If you are doing your existing contractual obligation, but your performance of existing contractual obligation, that you are supporting a promise from the third party, you had made a promise of the third party regarding this same contractual obligation, then that will be considered as sufficient consideration. Now let's understand this point with this case, Shadwell versus Shadwell. The claimant was engaged to E at the time of the engagement. At this time an engagement was an enforceable contract. Okay, so let's say there was a boy A who was engaged to a girl B. Okay, so A was a boy, B was a girl. So they had an engagement. Okay, engagement in 1840 was a contract that a two people who got engaged, it is necessary for them to get married. So it was a valid contract at that time. Okay, the claimant's uncle wrote him a letter saying, I will pay you 150 pounds per year during my life until your income as a barrister shall reach 600 guineas per annum if you marry E. Okay. So the girl's uncle of B, he wrote a letter to boy. He wrote a letter to boy in which he said that I will pay you 150 pounds per year, unless your income becomes 600. Okay. When you will promise to marry E, when you will promise to marry my I think marry his niece. Okay. So that was the case. Okay. Now what happened was that the boy, he was getting the payments, but once the uncle died, the boy, sought to recover the compensation from the personal representatives of the uncle. Okay. And the personal representative, they refused to pay him. They said that, marrying the girl is your contractual obligation. Why should we pay you? Okay, why should we pay you? So when the case was brought forward to the judge said that this was a sufficient. Judge said that yes, it was a contractual obligation of a boy to get married with the B if he has done an engagement. But the promise made by the third party, promise made by the uncle to the A, the boy is also supporting that promise as well. So his existing contractual obligation will be considered as sufficient consideration. So the representatives of the uncle, they have to pay the boy remaining amount, unless or until his income becomes 600 pounds per year. Look, very interesting case. In 1840, engagement was a contract. When you get engaged with a girl, it is binding on you to get married with a girl as well. So the was boy, have to marry the girl. It was his contractual obligation. But he was supporting the promise from the third party by doing his contractual obligation. And if he does so, then it is considered as sufficient consideration. If it is a sufficient consideration, then the promise, then the agreement between boy and uncle is a valid contract, because there was some sufficient consideration. So the representatives of the uncle, they are bound to pay the boy 150 pounds per year, unless or until his income becomes 600 pounds. Okay. The next is part payment problem. Now look, the general rule is payment of smaller sum doesn't cancel debt of higher amount. But there are 4 exceptions to that rule. If someone owes you 100 pounds, then when he will give you £100, only then the debt will cancel, right? When if I took the loan of £1,000 from someone, I have to pay him £1,000, only then the debt cancelled. The debt is cancelled, right? But there are four exceptions. In eyes of the law, the smaller sum can cancel the larger sum, but there are four exceptions. Okay, the smaller sum can cancel larger sum in these four situations. The first one is where the third party has made the payment. Look, for example, A, there was a person A and person B. A have to pay $500 to B. Okay, A have to pay $500 to. Now A, he got bankrupt. He do not have any amount available. He got bankrupt. He do not have any amount available. Now A had, let's say, another friend C. He asked C to pay B. Okay, now C give the B amount of $200. Let's say $200. Okay, and C mentioned that I only have this much amount of available. That A has gone bankrupt, so I can pay only you £200. So against that pound, please cancel the complete debt. Then the debt will be considered as cancel. Why? The law says that he cannot get $500 from A, right? But if some third party is paying on behalf of A, and whatever amount he is paying, he should have that amount, because it is better to get something rather than nothing. So B should get that amount. So the payment made to the third party of less amount can cancel the complete debt of the B. The first exception. So the third party payment is considered as extra consideration. It's considered as valid extra consideration to cancel the larger debt. Okay. Composition with creditors. This is regarding the liquidation of the company. Like for example, let's say the company is now shut down, and there are four creditors of the company: A, B, C, and D. And the amount that the company have left is only £1,000. Okay. Now, a company may owe, let's say, A £600, B, let's say, £300, C £400, D, let's say, £500. Now, company owes more. Company owes larger sum. But upon liquidation, they only have this much amount available to distribute to the creditors. So the creditors can make an agreement in which they can take the less amount according to their credit ratio, and agree to cancel whole amount of the company's fund. So the composition with the creditors, you can with the composition with the creditors, you can use the smaller sum to cancel the large amount of debt. Accord. Accord means both parties freely agree to part payment. Like for example, I have to pay you $500, but I requested you that I don't have $500 available. I only have 400. I will pay you 400. Please cancel my complete debt. So you can do that as well, because you are freely agreeing. Freely agreeing. You cannot forcefully force someone to agree for smaller sum, but if you are freely agreeing, you can do that. Satisfaction. Satisfaction means consideration might be payment at an earlier date, payment at different place, payment in different currency. Very important. Like for example, A have to pay B $500. Okay, and the payment should be made. The due date for the payment is 15 January. Now B requested A that pay me on 10 January, and you can pay me $400. Okay, so the due date is 15 January, and A have to pay $500. But because B want the payment at earlier date, then that $400 made by the A at earlier date will cancel the whole $500 debt. Okay, it will be considered as cancelled. Similarly, at different place, like for example, if I want to get payment from someone and I have to travel to some place, so obviously I have to incur traveling expense. So I will just ask other person to send the money. Okay, and he can say send, let's say, few less money. Okay, then I will consider that less money. I will take that less money and I will consider the larger sum, the larger debt cancelled. Okay, like for example, let's say, if let's say I live in a certain city, I live in London, and B lives in Manchester, two different cities. Now A have to make the payment of $500 to B. So A said to him that you can come and get the payment, but B, when he will go towards A, he have to incur like traveling expense of, like, let's say, $100. Okay, for example. So B can request A that share me the amount of $400. You come to me and give me $400. Okay, and I will accept that as my full payment. So that will also be considered as satisfaction. Okay, so these things, payment at earlier date, payment at different days, these are the considerations. These are the considerations to cancel the larger debt with the small amount. Similarly, payment in different currencies, like if I pay you in different currency, if let's say you want dollars and I only have pounds, then I can pay you less dollars if if you need them. Then those less dollars can cancel, the sum that I owe you. Okay, so that is known as satisfaction. That is very important point, the part payment problem. Now, there is another concept of doctrine of promissory estoppel, and this case is regarding that. So first, read this concept, the very important concept, doctrine of promissory estoppel. Doctrine of promissory estoppel, it is based on the principle of fairness and justice. It prevents person going back on his promise to accept a lesser amount. Doctrine of promissory estoppel, it is based on the principle of fairness and justice. It prevents person going back on his promise to accept a lesser amount. Now, what does this concept mean? Is this means that if I made a promise to you that I will, you can pay me lesser amount, then I cannot withdraw my promise. Like for example, if I made a promise to you that you can pay me 100 pounds. Let's say for example, the rent that you have to pay me is 500 pounds, but I made a promise to you that you can pay me 200 pounds only. Okay, now if you are paying me 200 pounds and in future I withdraw my promise and I claim on you, or I put a compensation on you, I say to you that give me my original rent back, 500 pounds. I cannot do that. This is what doctrine of promises estoppel says, that if you do a promise with someone, you cannot go back on your promise. Now let's understand this case with a very landmark case. This case brought forward the concept of doctrine of promises estoppel. Very important case. Let's go to the case here. So claimants lets a block of flat to the defendant in 1937 at annual rent of 2,500 pounds per annum. The defendant were going to sublet the flat. So basically there was an owner. He gave the flats for rent 2,500 pounds per year to Mr. A. And Mr. A was subletting the flats to other people like B, C, D, E. Okay. So owner gave the flat on rent to A, and A was subletting the flat to the other people. Now in World War II, the London was being bombed. Some of the flats become empty and it was impossible to relet them. In addition to existing tenants had their rent reduced, the claimants agreed to accept half of the rent for the rest of the war. Okay. So what happened was that, the flat were in London, and at that time there was a world war going on. And because of the world war, the London was, it was very difficult. The people were not living in London. So it was difficult to let the flats, basically to put the flats on the rent. So he requested the owner that reduce the rent by half. Reduce the rent by half. Because of the condition going on, because of the world war, it was very difficult to get the flats on rent. So the he requested the owner to reduce the rent by half. So he said that I will pay you 1,250 pounds per year. So the owner, he agreed that I will accept half of the rent from you for the rest of the war, unless or until the war is going, I will only take 1,250 pound from you. Okay, this person A, when the rent was reduced, he further reduced the rent for A, B, C, D, E. Okay, so for all the people he reduced the rent as well. So by relying on the promise of the owner, he reduced the rent of further to whom he has sublet the flats. Okay, now what happened was that the owner, once the war was over, owner put a claim of complete rent on A. Owner put a claim of complete rent on A. He said that, pay me the remaining amount, pay me according to the 2,500 pounds per year. But what did the judge said? Let's understand that. The full rent was payable from the end of the war. The judge said that, once the war is ended, after that he have to pay you full amount. Okay. The doctrine of promises estoppel would stop the claimant from recovering the full rent forgone during the war years. The doctrine of promises estoppel says that you cannot withdraw from your promise. The owner promised A that he will reduce the rent by half till the war is going. So he cannot go back from his promise. Okay. So High Tree House were expected to reduce their rent. High Tree House was basically the agent who was in between the A And High Tree House, or you can say Mr. A, by relying on the promise of the owner, he further reduced the rent of the tenants. He further reduced the rent of the tenant, which means that he was relying on the promise of owner as well. So the owner cannot claim the outstanding rent from the war period. After the war, he can do that, but if during the war, he cannot claim the outstanding amount. So this is what the doctrine of promise estoppel says. Okay, but this principle is subjected to following conditions. The first condition is there must be existing contract between parties. So there was a contract between owner and A. There was a contract. Claimant must voluntarily waive of right. The claimant who was owner, voluntarily means without any force. They agree on their own. They voluntarily agree. No one was forcing them. So owner voluntarily agreed that okay, I will reduce the rent for 120 half the amount. I will reduce the rent by half. Must be intention that defendant would rely on it. The defendant, who was Mr. A, he he should rely on that promise. Was he relying on that in this case? Yes, he was relying on the promise, right? And defendant must alter their legal position. The defendant, who was Mr. A, he changed his legal position, right? The contract between the tenants that he had done, he reduced the rent. So he changed his legal position, right? Uh, Before that, his legal contract was that he was getting, let's say, 100 pounds from the tenants, but after relying on the promise, he's now just getting 60 pounds. So he has change his legal position with the tenants as well. Okay, so if these four conditions are there, then the doctrine of promise estoppel applies, which was there in this case that we just studied. And in that case, the doctrine of promise estoppel applied, and the owner, who was claimant, cannot go back from his promise and claim the forgo run during the World War. The doctrine has following limitations. It has suspensory effect. Suspensory effect means effect for time being. Effect for time being. Like, for example, once the during the war, the promise estoppel was applying. But once the war is over, the defendant have to pay the complete rent. So it has just suspensory effect. Party seeking it should have acted fairly. If the party who was seeking the promise, basically, that was defendant in this case, they should also act fairly in that case, or fairly. Okay, if they were not acting fairly, then the the doctrine of promises doctrine will not apply. It is a shield, not a sword, which means it is a defense, not a cause of action. This is used as a defense tool. This is used as defense tool. Like, for example, if there is a problem that is going on, that is war going on, and there is a clear problem that tenants are not living in the London. So that is why, to defend yourself, the defendant is using this doctrine of promise estoppel concept, right? It is not an action thing. It is a defense mechanism. Doctrine of promise estoppel is a defense mechanism.